right, so everybody who thinks this is the Donald Trump deposition, you can go now. But for those who actually meant to be here to talk about NEPA and ESA today, welcome. It's really great to be here. Again, I've done this in the past. For my part, my name is Jamie Auslander. I work at Beveridge and Diamond as an environmental attorney. We're a law firm that focuses almost exclusively on environmental law and natural resources and litigation, and we do it mostly on the business and developer side. A core of what we do, we just work on the projects, statutes, regulations, and there's a lot going on in both NEPA and ESA. So this is a pretty well-timed program, as I feel like it usually is most Junes. So I'm going to start with a qualifier. I teach an entire full day NEPA class and I'm part of another one that's 3 or 4 days long. We have 2 hours to get through these two seminal statutes and have plenty of time for questions for you, which we totally encourage and want you to, again, send them in as you think of them. Logistically, we'll address them at the end, but we really want to spend a good chunk of our time here answering questions and talking about it, hopefully having a discussion about some of these issues which are really not settled. And to the extent you don't get your question in or you stay after, we'll stick around for a while. You could also email Jane or me, either of us, about NEPA or ESA afterwards too. Happy to answer your questions. So who listens to satellite radio? Just by a show of hands. And how many like the channel, the 60s on 6? So I admittedly also enjoy that and driving in some days with the Metro broken. Well, let's go back to that time just for a moment. I'm sorry, you have to look at my title. No, don't sleep on NEPA, and don't sleep during the NEPA either. So. Going back to the late 60s and early 70s, pretty much nothing going on. National price of average a gallon of gas was about 35 cents. A mobile phone meant that you threw your rotary out the window. Computers would have taken up this entire room. So anyway, we were not exactly as sophisticated as we were now, and that includes on the environmental side. But sort of around this time period, the effects of industrialization really became apparent, and the environmental consciousness really took hold over the country, and it manifested itself in Congress and even in Republican administration, Richard Nixon. And there was a lot of debate sort of about what to do. There were some one-off statutes like the Wilderness Act. There was an ancestor of the Clean Air Act, but there weren't really the comprehensive laws that you see today. And then you really start with NEPA and going through the 70s and even into the early 80s is really when you kind of have the golden age of environmental law. And what kind of got this all started, as in most instances, it was a calamity. We all are fresh off the Deepwater Horizon incident in the Gulf, and there's been a lot of government activity in response to that. Well, in this instance, it was the Santa Barbara oil spill in 1969, which was a pretty big deal. It occurred 3 miles offshore Santa Barbara and impacted miles of California. It was a very large cleanup effort, and that really focused, like, we need to do something now. And the thing that, the idea that came out was, let's declare a national environmental policy, and that really led to NEPA, or the National Environmental Policy Act, which is really viewed as sort of the Magna Carta of environmental law, and everything sort of flows through that. Though in terms of substance, NEPA doesn't bring that much to the table, and we'll talk about that. But the idea was that if we don't have NEPA, we don't consider the effects of our actions on the environment, then we're not going to undertake environmentally friendly actions. We're just not going to consider it in the decision-making processes. And a lot of things the federal government does have big consequences on the environment. I mean, we're not just talking about things the government builds, like New Deal stuff. We're also talking about things government approves, things government funds, highways, bridges, mining projects, oil and gas, renewable energy, all require the federal approval, without which you don't get to act. So really the idea was to get environmental concerns just plugged into that organically. Congress overwhelmingly passed NEPA. They did it almost unanimously. And Nixon, of all people, signed it into law on January 1st, 1970. So some of these other statutes, we're going to get into in future sessions of summer school, so I'm not going to address them right now, but just want to give you a sense of NEPA stood in the grand scheme of things. Also want to just cover one other background topic before we launch into NEPA, which is, especially for the non-lawyers out there, what are the various types of authority that govern under the law. So at the top, of course, we have the U.S. Constitution. Anybody who likes constitutional law, environmental law, is a really good field for you. We actually have a lot of constitutional issues that come up all the time, and I would have paid a lot more attention in con law had I known that. But takings under the Fifth Amendment, preemption, state and local preemption under the Supremacy Clause, interference with interstate commerce under the Commerce Clause. These are all issues that come up time and time again in our little world. Then you go down to statutes, which are enacted by Congress, and then statutes leave often a lot of gap filling or leave some of the implementation to federal agencies, and the agencies in turn pass regulations, which are published in the most in the Code of Federal Regulations. Some of it is unpublished. We're trying to get away from that, but these regulations also have the force of law and interpret the statute. They can't have a regulation that goes beyond the authority the statute granted. That's often an issue in litigation, but it's an important core principle. But obviously with Congress not doing very much lately, most of the action in our world has been in regulation. And in the next two areas, case law. So when there's a dispute, it goes to a court interprets the statute, regulation, makes a determination that binds. We have district courts throughout the country. We have appellate courts. We can appeal. There are 11 circuits in the federal circuit, and then there are the U.S. Supreme Court, and the U.S. Supreme Court gets environmental cases a lot, often under the Administrative Procedure Act. Again, if you take con law or administrative law, you'll see a lot of environmental cases. That's under the rubric the Supreme Court. And then what we're seeing a lot of, more so now is sort of agency guidance, executive orders, kind of looser things, internal manuals, policy guides, guidelines. They take a lot of different forms. And what these are non-binding. Legally, they don't bind you like a regulation does that goes through public notice and comment. However, from a practical matter, you better be prepared to comply with them. Agencies do comply with their procedures, and in most instances, if you have a project developer and you want to get your project approved and approved efficiently, you're going to bend over backwards to comply with the guidance. And there's again, issues. What can we do through guidance? What should we do through regulation? That's another sort of hot area of debate right now in environmental law. So with that sort of sidetrack, let's go back to why we're here today, which is first statute, the National Environmental Policy Act. Now, really, one important point, and you'll notice it's not the National Environmental Protection Act. And if you read a decision from a court that doesn't do this very much, you will inevitably see the National Environmental Protection Act. It's a common misnomer, but really it's important because what it is, it's a policy. This is an aspirational act that seeks to, again, impose environmental considerations on federal decision-making, but really it has two main goals. One is to ensure that you have informed decision-making, so the decision-maker, whoever in the agency is going to make the decision, considers the environmental impacts of that decision, not just today, but reasonably foreseeable into the future. So we're making holistic decisions, not in a silo and not ignorant of environmental impacts. The other big purpose is public participation. So to give it a sense to, you're not making decisions behind closed doors. The law is going to be passed that's going to amend the Freedom of Information Act, same kind of spirit, that we want these decisions to be out in the public. We want public to be able to access and comment on methodologies, reasoning, data, and really participate in the decision. So these are the sort of two animating principles of NEPA. And just as I explained, we have the statute. Statute's really short. We posted online. You can look at them afterwards. The statute, the regulations, we'll talk about in a second, and some of the key guidance materials. And you can read those and commend those to read. I mean, some of those are dated. One of the 40 most common questions under NEPA is a 1984, 1985 document, but it's still vibrant today. And there's a lot of guidance that's been put out by various agencies. The main agency under NEPA is the Council on Environmental Quality. This is part of the White House. It has a director, it has staff, and they really are the NEPA overseers. They are assist agencies implementing the project. They carry out various White House initiatives, climate change, and some task forces and other things. But under the CEQ regulations, these are government-wide. And then agencies have their own NEPA regulations that are applicable to their own projects. So every agency is doing different things. If you're NOAA, National Oceanic and Atmospheric Administration, you're doing different things than the Federal Highway Administration. You're doing different things than the Bureau of Land Management. All of these agencies have to comply with NEPA, but it's going to apply in different ways. So agencies pass their own regulations. And how are they different? These regulations specify, for instance, for certain kinds of projects, we're going to do the highest level of NEPA review. For others, we've done these a lot, and we think that they basically should be categorically excluded from detailed NEPA review. And it gives you, again, there's some ambiguities there, but more of a sideboards to operate with. Then again, you have various guidance, and they're giving you some links, and there's a lot of them here too. Last main point, states. States have their own little NEPA, and I hesitate to call it little NEPA, even though I have it on the slide, because some of it is big NEPA. California is your biggest example of that. The California Environmental Quality Act, or CEQA, really is another step forward. Unlike NEPA, CEQA requires you to consider all the impacts and to undertake affirmative actions to mitigate and minimize the effects of your project. So again, every state, if you're operating in a state, you want to take a look at federal NEPA. You may want to also take a look at what the state's doing on the state side. Okay, we're getting close to the 50th anniversary of NEPA, and we already talked about a couple of the goals. Again, it's a sort of look before you leap mentality. We don't want to act and then figure out 5 years later, oh my God, I never thought it would have X impact. It would wipe out X species, and now there's just nothing we can do about it. So the idea is to get all of that on the front end. But again, under NEPA, if you determine your action is going to blow the planet up, you can take the action. You can adopt the action to blow the planet up, because it's not a bar to anything. If you've considered and you've gone through all the process and you've built your administrative record, you can basically proceed under NEPA. Now there's other statutes that may limit the Clean Water Act or Clean Air Act or land management statutes that might limit what you can do. And there's also a lot of guidance. Again, we talked about guidance as a practical matter. It's constraining a bit what you can do, but NEPA itself is a procedural statute. All right, so does NEPA apply, or wait, so can I go home now? So NEPA requires federal agencies to prepare an environmental impact statement or something less in connection with, and this is the key phrase, proposals for major federal actions significantly affecting the quality of the human environment. So that's a mouthful, but you come away with nothing today from NEPA. That's the key question that you need to ask. Now, breaking that down, what does it mean? Basically anything the federal government does. The federal government, again, is going to issue you a permit. It's going to issue you funding. It's going to issue a grant. If it's going to issue rulemaking, it's all going to be covered under NEPA. But breaking this down a little bit, major federal action doesn't mean anything independent. So you could just sort of put that away. But what do we mean by a proposal? What a proposal is that an agency has a goal and is actively preparing to implement that goal. So what we're talking about is NEPA applies when we're actually going to do something, or something's really in our mind's eye. We're going to thinking about taking action. What's the problem if we act too soon? We act too soon, there's insufficient information, we don't know what we're doing, the analysis is really valueless because it's just too fuzzy and it's too undefined. Of course, if NEPA review starts too late, then we've already have sort of predetermined outcomes and we've defeated the purpose of the stop and think. So again, we're talking about any kind of action, BLM approval of a fracking well on federal land, Forest Service adoption of a forest management plan, construction approvals for a state highway project, Fish and Wildlife Service issuance of a permit to take endangered species on public or private land, offshore wind regulations, all this triggers NEPA. But sometimes we don't. Sometimes it's unclear if we have to do NEPA. So court decisions. Court decisions not subject to NEPA because they're not federal agency actions. Same thing with legislation. Congress is not subject to NEPA. Things the president does directly. The president's not a federal agency, not subject to NEPA. Purely state or private actions that don't have a federal nexus, those are not subject to NEPA. They may be subject to the state analog, but they're not going to be subject to NEPA. Closer questions, what about something like a compelled agency action where the statute says if you meet X, Y, and Z, the agency shall do A, B, and C, the statute shall do D. The agency shall do D under the statute. And in those instances, you have a pretty good argument that you don't have a NEPA obligation under what's kind of emerging as a non-discretionary action exception. So one example of that is in the mining world. If you place a claim and you find a valuable deposit of minerals under the statute, you are entitled to a patent. Now there aren't many patents being given anymore, but that kind of example, the issuance of a patent, not trigger NEPA because the statute says this is your result if you show the following things. But other ones are statutorily exempt. So EPA actions under the Clean Air Act or the Clean Water Act, often not subject to NEPA. Superfund site cleanups, often not subject to NEPA. EPA hazardous waste permitting under RCRA, the Resource Conservation Recovery Act. That's not subject to NEPA. EPA pesticide registration, not subject to NEPA. And so again, some of these are under statute and some of these are under courts interpreting statutes under a functional equivalence type of thing where the agency is in issuing its permit already has an environmental process built in, and NEPA would just be basically another layer of paper that they don't have to do. So in several instances, those kinds of more routine acts are not subject to NEPA. But the courts are not entirely consistent here, so it's not black letter by any means. What about like environmentally beneficial actions? So the courts are split on that, and sort of one example of that is when EPA designates critical habitat under the, I'm sorry? Fish and Wildlife Service, sorry, excuse me. When Fish and Wildlife Service designates critical habitat under the Endangered Species Act, the 9th and 10th Circuit have come to different conclusions about whether that triggers NEPA. But the main thing is beneficial impacts are included in NEPA's ambit. You should consider the beneficial impacts of your actions as well as the adverse ones, but purely beneficial actions don't necessarily get a waiver from NEPA review. What about a project where there's only a really small component that has a federal nexus? So if you're building a 100-mile pipeline and you have to cross a small stream, that would be waters of the U.S., it would be under Army Corps of Engineers and EPA jurisdiction. Do you need to do NEPA for that? And the answer is yeah, but the question is how much? Are you just going to look at that action, or are you going to look at the entire project? There are guidelines on how to approach that, and more than I have time to get into now. But again, that's a hotly contested issue where agencies and offices within agencies don't necessarily have the same views all the time. This is sometimes called the small handles issue. So again, federal actions under NEPA are those that are potentially subject to federal control or responsibility. It's possible, though it's difficult to tailor your project to avoid federal nexus and thereby avoid NEPA review. Now, one big area where people fall into trouble is segmentation. So if we decide to do NEPA, NEPA's triggered. It doesn't answer the question about what exactly are we going to study. In other words, what is the federal action that we're going to review? And that's a great question. And the great answer I have is that it depends. It's really critical to take the time to examine the full scope of your proposal. The segmentation issue is if you have, again, I'll take my 100-mile pipeline, and let's say I'm going to build it over a 10-year period, and I'm going to do it 10 miles at a time. Each one of those in isolation may not be a significant impact, but taken together, that is going to be a significant impact. And so basically cutting down your action into such small pieces that you avoid significance is the epitome of segmentation. An example recently, the D.C. Circuit Appeals Court struck down NEPA review for a FERC approval of a natural gas pipeline project. Why? It was part of an overhaul of a larger pipeline system. And I'm sorry? That's my case. That's your case, so we'll talk. You can talk more about that. But anyway, it's a big issue, and often it comes up when FERC or other agencies haven't been challenged a lot under NEPA, and it's something that's immediately looked at. Another example, if you're dredging upstream, you have to look at the impacts downstream. If you're building a golf course and part of it is a bridge across a navigable water, not necessarily the whole golf course is going to be included in your review. That wouldn't necessarily be segmentation, but that federal piece, you want to make sure the federal scope of the action, you're including everything that is arguably the federal action. All right, who's doing NEPA? I think we're doing good on time. So the players, right? So we have a lead agency appointed under NEPA, and sometimes that's all we have. Who's the lead agency? That's usually the action agency, the agency you're applying to for the permit. And then there are cooperating agencies or participating agencies, and don't be misled. These are not just federal agencies. So anybody who's going to have a permitting responsibility in the project, any agency that has a special expertise or viewpoint to add to the project, states, localities, tribes, Indian tribes, they all can be participating in the process. And one of the things you have to really do at the front end, which a lot of people skip over, is who are my players, who needs to be at the table from the outset. The agencies don't do all the work themselves. They rely a lot on project applicants. They also rely a lot on third parties, third-party consultants. You'll see, if you look at any number of environmental impact statements or environmental assessments that are prepared by a professional industry that has grown up around NEPA that specializes in writing EAs and EISs. And they do a lot of the work. Now, can you just pull one off the street? Not really. It's still the agency that's responsible for completing the NEPA. The agency has to have independent oversight. The agency ultimately has to issue the NEPA document. But usually you can structure these things through an upfront contract or an agreement where basically the project proponent pays for the review to be done. The third-party contractor does the work under the supervision of the agency. And that's how often we speed things up. Of course, in today's federal workforce, there's so much to be done, so little money. It's really a necessary step in order to make sure that the machinery of the government keeps moving forward. And the public, we can't forget about the public. The public through commenting, right? Part of the big impetus of NEPA was to bring them into the process. There are several opportunities for public comment, and the agency have a responsibility to respond to those public comments. So the public, of course, is a big player in NEPA. Now, there are several ways that you can complete your NEPA reviews. And so the next step is to ask what level of analysis that you're going to engage in, and what documentation are you going to need to show your NEPA compliance. As a global point, we're going to get to this in a couple minutes, but NEPA, when NEPA compliance is challenged, the basis of the challenge is the administrative record. It's a term of art, but basically that's everything that was before the decision maker at the time. And what a court is looking at is did the agency look at everything? Did they reason through everything? Did they consider comments? And if they did and they documented it in the NEPA document and supporting memoranda, technical reports, what have you, then often the agencies get deference, and then the decision will be upheld against the NEPA challenge. But it's really important to think about at the outset what kind of review you're going to need, and not just that, but what kind of documentation you're going to need under that level of review. Going from the top to the bottom, the top is most intensive, environmental impact statement. Next down is environmental assessment, and below that is a categorical exclusion. There's actually a fourth below that. It's called a DNR, or DNA, or determination of NEPA adequacy. This is not that pervasive through the government, but some agencies have regulations, like the Bureau of Land Management has a regulation on it. Other agencies do it as a matter of course in certain instances. But what that means is that we basically, for this action, we think we've already considered all the impacts for it, and we're just going to incorporate that analysis and issue a DNA that we've done enough. I just wanted to point that out to you because you may run into it, especially if you're doing kind of federal resources stuff on public lands. But what's the trigger? I mean, yes, I don't know, certainly not. The question commonly, it's the same question I posed to you before. Is it a major federal action significantly affecting the quality of the human environment? So we talked about some of the words in there, but the most vexing question that you see agencies grapple with and courts grapple with is significance. And what is significance? And I wish I could tell you in really narrow terms, but there's a lot of stuff that goes into significance, and there are really two kinds of considerations. One is context. So where are we doing the project? Are you looking at it in isolation, or are you really looking at the on the ground where the project's going to happen? So, for instance, the impact of building a shopping center that requires filling 3 acres of wetlands may be insignificant in a 2,000 acre wetland, but may be significant in a 6-acre wetland, where you're taking 50% versus a small portion of that. Again, where are we doing the action? The other is the intensity or the severity of the impacts. And CEQ's regulations that are government-wide set forth a list of factors that you should consider when evaluating the intensity of the project. And these aren't exhaustive and these aren't dispositive, but again, you have to consider adverse and beneficial impacts. You have to consider highly uncertain risks where we're doing something novel. We haven't done it before. You really want to give special attention to that and err on the side of analyzing something we don't fully understand. But there's a sort of slew of factors that go into that. One important point is agencies do not need to consider remote or speculative effects, and then that's important. So it has to be a reasonably foreseeable effect when you're looking at it, for significance, or when looking at it in the NEPA review. When you're looking at emerging issues like climate change, this is a big. It comes into play. How far out do we need to look? What worst case assumptions do we need to assume, and what actually isn't foreseeable? If you're going to undertake, let's see, you're a development agency and you have 5 projects on the horizon. 2 you've committed to, 3 are just sort of in your mind's eye. Good argument that these 2 are going to have to be considered, the one you're doing now and the one you're planning on doing and the one you're going to do in parallel. But your 3 future actions, if they really aren't formed yet or there isn't commitment yet, they may not be reasonably foreseeable. And so questions, again, about scope, and what are the effects that we're going to be looking at. What kind of effects are we looking at? So we're looking at ecological, your physical environment, your land, your water, your air, species, targeted species, non-target species. You're looking at land use patterns. You're looking at historic and cultural resources that are in the area. You're looking at socioeconomic impacts to the extent they are related to the environmental impacts. So, for instance, if you're looking at a product of biotechnology, a new genetically modified crop, and you're analyzing its approval for nationwide use under NEPA, you consider sort of the the domestic and international trade aspects of that. If we license that, what would be the effect on trade? Would our imports stop being accepted into a country that has more sensitive GM regulations, et cetera, things like that. So, and really another kind of outcrop of that has become more prominent in NEPA analyses is environmental justice. And there's a big emphasis on environmental justice from EPA. They just put out new technical guidance on that. But are we having disproportionate impacts on disadvantaged populations, minorities, children, seniors? Those are the things that we want to be looking at. But there are three different lenses that we want to look at. One is direct effects, second is indirect effects, and the third is cumulative effects. All right? Another really important point. So direct effects, what's the easiest way to think about this? These are stuff that happens because you undertook the action. It happens almost immediately. So you cut down trees, you fill a wetlands, prepare land for construction of a shopping center, right? That forest clearing and filling of the wetlands, direct impacts of the action. I want to build a shopping center, this is what happens. Indirect effects, these are also caused by the action, but they happen further out in time. They're further removed in distance, but they are still reasonably foreseeable. So the most common aspect of this is growth-inducing impacts. If I build a road, yes, everything I build my road through is going to come down, and those are my direct impacts. But because I build a road here, I may attract more development, commercial development. I may attract more people moving to the area, more cars, and what are the effects of that? So that's sort of induced growth. That is an example of an indirect effect. Cumulative effect is your past, present, and reasonably foreseeable future actions that may interplay with the action that you're undertaking and what the global effects of that are. So again, your impact may be insignificant. Just drilling your well here or building your road here might be small, but in the grand scheme of things, if there are a whole bunch of projects that are pending right around it, you have to, again, look at the broader scale. Cumulatively, there may be significant impacts, though individually it may be insignificant. So, let me just skip ahead. The one thing that you should keep in mind, again, I'm going to cover very quickly the different levels of NEPA review, but one thing to keep in mind is agencies legally can always do more NEPA. So you can't go to a court and say the agency refused to give me a categorical exclusion. They want to review this under environmental impact statement. I think that's going to take a lot of time and money and make them do it. No, that doesn't fly. The agency can do an environmental impact statement full-blown on anything they want. Do they want to? No. I mean, it takes a lot of their time. It takes a lot of their money. There's a lot of advantages for the agencies too in taking the smartest approach to it. But they always can do more NEPA. So that's really something fundamental to understand. But the most common thing agencies do, categorical exclusions. You don't hear about them a lot because they happen underneath. They aren't, often made public. They don't receive public comment. But, what are they? They're a category of actions which do not have a significant effect on the human environment individually or cumulatively. And these are born either of statute, so Congress sometimes says in statute these following things are things that are going to be categorically excluded, or the agency writes them in their regs based on their experience. So we have built 1 million roads. We think that this type of building a culvert doesn't have environmentally significant consequences, and so we're going to apply a categorical exclusion in most of those instances. There are hundreds that are available, and they're used a lot. But one catch, you can't have unusual circumstances. So again, if you're taking that routine action, but you're taking in a particularly sensitive area, you should consider whether there are unusual circumstances. In that instance, you may want to do more significant NEPA review. But there's been a lot of attention lately by CEQ, by the White House, on categorical exclusions, how we establish them, how much we're using them, are we overutilizing them, are we underutilizing them, are there some legacy ones that just don't work anymore, are there ones that we should have that aren't promulgated yet? So it's sort of an evolving thing, but something to think about if you're approaching a project. Do I have a categorical exclusion that might apply to me? Next up is environmental assessment, and this is your sort of default if you don't know what your impacts are going to be. And what happens at the end of environmental assessment is you either reach a finding of no significant impact, or a FONSI, and you're done, or you reach a finding of significance and you have to do an EIS. It's really inefficient to do an EA, find significance, and then have to do an EIS, starting the whole process all over again. So typically, if there's a good chance you're going to end up in the EIS world, you want to go to the EIS, you can do an EA, you want to undertake actions that are going to minimize significance of an EA. What does it mean? Well, one thing you can do is something called a mitigated FONSI. So this was recently upheld by agency guidance. There was sort of doubt whether these are appropriate or not, but basically where you have a project, you undertake mitigation measures as part of the project to reduce the impacts, and then you can issue a finding of no significant impact. The catch for that is you have to perform the mitigation. So if you don't perform the mitigation, then you open yourself up to potential reopeners and other issues. But these EAs, there's no prescribed format. Some of them are really small, some of them are thick. And the goal is to briefly describe your purpose and need, your alternatives, the environmental effects of your actions, who you talk to, whose perspectives were included in the analysis. All right, environmental impact statement. Is it really different than an EA? Well, procedurally, yes. Again, this is the most rigorous level of NEPA review. For an EIS, there's a lot of procedure. You have to do a formal scoping process. Before I even propose what I'm going to do, I have to ask the public, what should we be thinking about? What kind of possibilities should we be thinking about? You know, we need transportation solutions. Should we be thinking about transit, road, the buses, rail? You know, what should we be thinking about? And that's published in the Federal Register. Comments on that. The agency goes and does a draft environmental impact statement. Public comments come in on that. Final environmental impact statement at the end. The agency issues a record of decision, whatever it's going to do. Okay, I'm going to cover this kind of quickly because you have the slides. But one thing I just want to show you, the EIS has, the idea was never to bury you in paper. The idea was to ensure that you have sufficient consideration for these, typically complex actions. It's a mega project where it's a program that's going to have nationwide impacts. We want to consider all the effects of that. Give you a sort of visual example. What I'm holding in front of you here is an environmental impact statement from 1971 for exploratory oil and gas drilling offshore of California. So again, 2 years after the Santa Barbara oil spill. This is what the government put out. And this is their environmental impact statement for, again, where there had just been an environmental disaster to continue an exploratory drilling. Okay, that's one. This was last year on a project that I'm working on. This is the EIS, and this is technical appendices to an EIS. Same levels of review, right? I mean, it's the same statutory requirement, but you can see sort of what we're doing now and what we used to do. I have one in my office that takes up an entire file cabinet. That's one EIS. There again, for several reasons, we've gone to more and more paper. But that is the trend. And you get EAs that are this long also. So what is really the difference between an EA and EIS? Not really that much in practice of what you're going to analyze, but in terms of procedure, there is a difference. Often advice to clients is if you have a doubt, do the EIS. Why? Because the first, if you're going to get challenged, the first argument always is you should have done an EIS when you only prepared an EA. If you do an EIS, you take that argument off the table immediately. So again, an EIS kind of has a fairly standard anatomy. You can see it on the screen, but let's talk about a couple of big things here. The purpose and need is always your starting point. And it's only a few words or a couple paragraphs, but it really takes a long time and should take a long time to do. Why? It's the foundation. It's the whole foundation of the EIS. Why are we acting? What are we trying to do here? And if we haven't sufficiently thought about the purpose and need, if the purpose and need is too broad, if the purpose and need is too narrow, that's going to set everything of what alternatives are going to meet that purpose and need and what the effects of those alternatives are going to be. So it's really that fundamental starting place. Now, agencies, I think, do a pretty good job of this. Purpose and need statement has only been overturned once, ever, by a court. It was an instance where it was just it was in the context of a 404 permit of the Clean Water Act, and the agency really just blatantly ignored everything that was coming in, and it was a poorly written purpose and need. But agencies get a lot of deference on purpose and need. But you don't want to constrain it so much. Now, again, the heart of the environmental analysis is the alternatives. You have to have at least two. You have to have no action alternative. Are we going to do nothing, or are we going to do the proposed action? And then there's a reasonable range of alternatives along that spectrum, and there may be some alternatives within that. Is that an infinite number? No. We're going to look at 30 alternatives? No. I mean, if there's different alignments, we may look at alignment A, alignment B, and C with slight, additions or little tweaks in the alternatives analysis. But you want to ensure that the alternatives are practicable and feasible, that they can be done. They have to meet the purpose and need by definition. If it doesn't meet the purpose and need, it's not a reasonable alternative, and you can reject it. And it has to. Lost my place. And it has to be economically. And that's part of the feasibility determination. So your alternatives analysis can be as small as 2. It can be any number of alternatives. But for alternatives that are put on the table, let's say by public comments, or ones that have been debated for a long time, the purple line is a good example of that. It's been, are we not going to do it? Are we going to have buses instead? I mean, all of that has been explained. But any of those proposals, you probably want to have an alternative section on that. And if you're going to dismiss it at the outset, that's fine. You just have to explain why you eliminated it from detailed consideration. So you want, again, it's all about the paper. You're going to be judged by the administrative record. You want your record to be pristine and complete. Now that said, sometimes it is a binary permitting decision. Issue the permit or don't issue the permit. There's not conditions. And then it's a fairly simple purpose and need. We determine whether we issue the permit, and alternatives, issue the permit, don't issue the permit. That happens. And then you want to describe the affected environment before the action, and then you want to assess the impacts after the action. So it's not rocket scientist. I mean, we just want to ensure that we understand what the ground looks like, and we want to understand the incremental impacts of undertaking the action. We want to summarize that, and we want to do that in paper. Okay, we kind of talked about the way that this goes procedurally. You issue a final EIS, you have a record of decision, and that record of decision is your final agency action. That's when you can sue if you believe that there were NEPA or other substantive issues with the decision that was made. Now, are you always done with the FEIS? No. There's supplemental sometimes, and you have to consider supplemental EIS when there are substantial changes to the proposed action or when there's significant new circumstances. So again, that's not, I got a comment where, a new study was put on the table and, for the first time, and I have to consider that, I start all over again. No, I mean, that's not that. But let's just say your fundamental assumptions have changed. You're relying on a population projection, and it just turns out it was just completely wrong. Or you find there was an error, a fundamental error in your analysis. That is a change that you may want to consider supplementing your EIS, and that would go out for public comment, and you can get that finalized. But if your action has changed significantly, if you're going to change your purpose and need, for instance, if you're going to radically change your alternatives that you're considering, you may want to consider doing a supplemental EIS. If it's a big change, you may want to consider doing what's called a revised draft EIS. You basically put the DEIS out again for public comment before you finalize it. That also happens sometimes. Now, we're not always writing from scratch. There are strategies under the existing rules. It's being used with more frequency. I think it's a good thing. You want to see what's been out there. Have there been similar actions that have been undertaken recently in this area by my agency, by sister agencies? What in their analysis can I incorporate by reference so I don't have to start all over again? Sometimes you can just simply adopt an analysis. Sometimes you can incorporate reasoning and add on to it tailored to the action that you're talking about. Sometimes you can go top down. If you have a really programmatic high-level EIS, for instance, I'm going to promulgate new rules that allow development of offshore wind. But then I'm going to look at individual areas, whether wind is feasible here, New York, Virginia, North Carolina. You could tier off of that programmatic examination of what impacts would it have off the East Coast, and then have your second layer tier down, may only be an EA, but basically look at the additional impacts that are site-specific for that. Tiering happens a lot. Incorporation by reference happens a lot, but that's something to look at. Make sure you're not starting from scratch. One really good example, it's the last one, is the climate change. So again, if we have to start from scratch and do a literature review of climate change and look at the impacts and run equations, no, I mean that's not the idea. The idea is if we understand the impacts on climate, we should be able to incorporate those impacts. But again, it has to fit the project. You have to explain why you're doing it and why it fits. Okay, again, it's a procedural statute, but there's a lot of NEPA litigation. The government has never lost a NEPA case before the Supreme Court, ever. They have lost in district court, and they have lost in the courts of appeals. And ultimately, the claims are you should have done an EIS when you didn't do an EA. You didn't consider X impact at all. You didn't respond to X comment sufficiently. Your information isn't supported by your conclusion isn't supported by the administrative record. These are the common themes that are brought. NEPA does not confer jurisdiction. You bring a claim under the Administrative Procedure Act, and your claim basically is the agency acted arbitrarily and capriciously by not undertaking its obligations under the National Environmental Policy Act. These are typically summary judgment cases, not heavy on discovery. And on the merits, courts are deferential. They apply a rule of reason, and they look at whether the agency conducted a hard look at the issues and articulated it in the administrative record. But again, you kind of differ by court. Some courts like to fly spec more closely, and some give fairly broad-based deference. A lot of it depends on what judge you get or what jurisdiction you're in. So going forward, what are the issues with NEPA? Well, again, heart's in the right place, but the devil are in the details. Again, we have sort of this expectation now that projects are going to require a long time to permit, in part because the environmental reviews need to be completed. If you have to conduct surveys or long-term studies, you're looking at years. Some NEPAs can take 5, 7, 8, 10 years. It happens. And why does that happen? Well, you have agencies with different priorities. So even within a single Department of the Interior, for instance, you have the Bureau of Land Management, for instance. That's a heavy development agency. And you also have the Fish and Wildlife Service under that same umbrella, which is largely a resource agency. And so, they have different priorities. And how you get them to work together to address all their concerns to get a project that makes sense and incorporates those environmental considerations is difficult, and that could take a long time if there's not strong leadership or a plan in place at the outset. You have sort of lack of federal and state coordination, duplication of effort. You have sequencing problems. So sometimes an agency will wait for agency A to finish its NEPA analysis before it begins its work. I mean, that doesn't make a lot of sense because you're just sort of doing it sequentially. What the stress has now been is parallel NEPA reviews, integration, laying your concerns out at the beginning, holding agencies to their comments, and really having that melding at the front end rather than withholding or doing things for the last minute that could derail a close to final decision near the end of it. We are making progress. There are a lot of good developments that have happened, and NEPA has the attention of agencies, Congress, the popular media, the Congressional Research Service studies on that. How many EISs are we doing? How many EAs are we doing? There's a proliferation of dashboards where agencies are putting up on their website, not just for EISs, but EAs too, about where they are in the process, what's the timeline look like, how far along are we, if there's a hang-up, there's a process to elevate that dispute to a higher level decision maker so it doesn't just linger and sit out there. We're integrating planning in NEPA more, so when we're doing resource planning for large swaths of land, we're considering NEPA there too, so that when we actually want to undertake a certain kind of project, we've actually contemplated that project being undertaken when we're doing the land use planning for that. We've talked about concurrent consecutive reviews. In certain areas, even the Department of Transportation, for instance, Congress enacted a couple years ago a statute called MAP 21 that actually allows the Department of Transportation to fine other agencies when they don't get their reviews done timely, and there are regulations. Congress told DOT to do that. That's probably a difficult meeting for agencies that sit in there. They don't like to use it, but it is a tool that's out there. And there have been things, of course, that, depending on where you sit, there are statute of limitations for bringing actions. After the NEPA document is issued, there are now 150 days statute of limitations in many instances to bring it, as opposed to the 6-year statute of limitations default. Some issues that you probably are going to see or you haven't seen, we've been waiting a long time on greenhouse gas emissions. How do we consider greenhouse gases under NEPA? There's some draft guidance that's out there. There was revised draft guidance that was issued. And now we're waiting on the final. You have Congress suggesting that maybe they can't, CEQ can't issue this guidance because they don't have a permanent director that's been approved by Congress. All kinds of sort of games going on, but the GHG guidance is not final. And when it is final, it won't be legally binding, but it will, again, be practically binding. But you already see the draft being incorporated in some decisions, and you even see the draft guidance being cited in court sometimes. Again, scoping and cumulative impacts, that's going to be a big deal. For instance, if you're leasing oil and gas onshore, do you have to consider the impacts of utilizing that oil and gas after it's pulled from the ground, what those climate change impacts would be? The answer increasingly is yes. Third is a substantive kind of elements. Again, NEPA's procedural, but to the extent you're including mitigation in there and you're adopting mitigation measures that are going to be required in the final action, that really kind of has a substantive-like component on it. And you may have seen in the end of last year, the President put out a memorandum on mitigation. And basically, it does a lot of things, but government-wide applies a no net loss philosophy. And so in implementing that, our agencies and their NEPA reviews are going to select the mitigation that they identified. Are they going to be more inclined to do that? And if mitigation isn't effective, or is that going to provide a ground to reopen the federal decision? If it's not adequately funded, is that going to be an issue? So again, kind of substantive-like elements on the fringes of the NEPA review, but kind of incorporating. And then these continued efforts to reduce time and cost. Again, you get these whole bunch of legislation. Some of it is crazy, some of it is more rational, but nobody's talking about amending NEPA. They're just talking about amending how we do decision making. So I'll just end with some best practices. NEPA requires stop and think, not a specific outcome. Build your record. It's always record, record, record. Put it on paper. Do memoranda. Document your conversations. It's okay to have bad things in the record. Have to be everything about the project is rosy, honky-dory. There's probably going to be some bad things, and that's fine. We like to see that. Those are opportunities to address those and make a decision on the record as opposed to in a court brief. Acknowledge issues and information gaps. Don't brush them under the rug. And again, continue to stay abreast of what's going on and be actively engaged in the agency's efforts to do things faster without making environmental concessions. So that's my lovely grill, and I will hand it over to Okay.
Okay, great. So I'm going to talk about the Endangered Species Act, and I want to harken back to how Jamie opened up discussing how NEPA came about, because you know, in many ways, in the late 60s and early 70s, it was a time when we could really see the problems of industrialization development that had not yet been effectively addressed through a standard regime of federal law. So, for example, with the Clean Water Act, a huge motivation behind implementing a system for permitting water pollution was the Cuyahoga River literally caught on fire because of water pollution. With the Clean Air Act, you could see in the cities that there was smog. Your clothes would be dirty. It was visually apparent. And with the Endangered Species Act, there were a number of iconic species, you know, what we call charismatic megafauna, that were vanishing. A totemic example is the bald eagle, because of the use of pesticides such as DDT that caused eggs of birds to become soft. When the birds tried to incubate their eggs, they crushed. And so, you know, the bald eagle and other raptors were, you know, on the verge of extinction. So, you know, this led, in that sort of halcyon era of congressional cooperation, in the late 60s and early 70s, to a perceived need to do something to protect these species and their habitats. There were a couple of predecessor statutes to the Endangered Species Act of 1973 that I won't get into, but just understand that this was something that was visually apparent to the American public and to Congress and the President that resulted in the Endangered Species Act of 1973. Unlike perhaps some of the big deal problems that have been addressed through the Clean Water Act, we don't have rivers catching on fire anymore. You know, through the Clean Air Act, you know, our air is certainly a lot more breathable, especially in large cities, than it used to be. You know, we are still in an extinction crisis globally. The book, The Sixth Extinction, came out a couple years ago. There's a new age. It's being described as the Anthropocene. You know, unlike, you know, previous geological ages, it means essentially that, you know, the sixth great extinction of animals, plants, and other forms of life on this planet is being driven by human activity. The International Union for the Conservation of Nature puts out a red list. This is, you know, of species that have been assessed, and, you know, let's be clear, a huge number of species on the planet have not essentially been assessed for endangerment. You know, what is the status of the species that has been assessed? What can we say globally about how various families of species are doing? So the IUCN, you know, publishes and updates these peer-reviewed lists. This is not a graphic that they do. This is essentially another group put this graphic together. But to the extent that it kind of portrays some of these major categories of species and how they're doing, you know, it shows that of mammals, for example, 26% of all mammal species that have been assessed are critically endangered, or vulnerable to extinction. 41% of assessed amphibians, 33% of reef-forming corals. I'm sure everyone has seen the news about what's happening to the Great Barrier Reef in Australia. Sharks and rays, 31% of species are, you know, vulnerable to extinction. 13% of birds. So, you know, even though the Endangered Species Act and similar conservation statutes and efforts have done a lot to reverse these trends for a number of species, such as the bald eagle, which is no longer endangered and is no longer on the Endangered Species Act list of protected species. Unfortunately, the crisis of extinction, both domestically and internationally, it's an ongoing crisis. World Wildlife Fund put together a Living Planet Index a year or two ago. And one of the things that really struck me about this is that between 1970 and 210, just in terms of like population numbers of terrestrial species, like the actual numbers of the species, declined for 39% for terrestrial species, you know, 76% for these freshwater species, especially amphibians, in a huge crisis, 39% for marine species. And this is in the lifetime of, maybe not all of you in this room, but my lifetime. I was born in 1968. So, you know, in 40 out of my 47 years, half the animals almost have disappeared, and that's extremely frightening, you know, not only for the notion that, you know, species have intrinsic value, but also because humans depend on wildlife. I mean, we eat a lot of them, for example. This is a report that came out last year, the Living Blue Planet report. 50% of all fish in the ocean gone between 1970 and 2010. You know, sharks and rays, which are, you know, top apex predators and are, you know, vital to healthy ecosystems. As many as, you know, 90% of some of these sharks are just gone from the ocean. So, you know, the extinction crisis is certainly not over, even if we have had, you know, individual success stories, particularly with respect to the fact that, you know, we mainly don't kill whales anymore. You know, we've protected bald eagles, grizzlies, wolves. A lot of our charismatic megafauna have rebounded, but the problem is far from done. So I'm going to go through the Endangered Species Act, and, you know, as with NEPA, it's a really short and sweet statute. Unlike the Clean Water Act or the Clean Air Act, you can get through it pretty quickly, and I commend it to you because it's an extremely powerful statute for, you know, its brevity. So I've got the citations here. As Jamie mentioned, you know, the regulations are critical. You know, the statute is the skeleton, it's the framework, but the regulations are the meat on the bones, and you really cannot understand the Endangered Species Act without understanding the regulations. So, you know, Congress, in a very visionary sense, when it was looking at the species extinction crisis as it understood it in the early 1970s, understood that species cannot be conserved in a vacuum. All species have habitat, and without habitat conservation, you can't have species conservation. So this very forward-looking set of purposes says that you have to conserve species and their ecosystems. And you have to, we'll talk about conservation in a minute, but another aspect I really want to point out about the Endangered Species Act, especially because we have such a much greater sense of the global extinction crisis, is that the Endangered Species Act has not only domestic but also international aspects. So one important purpose of the Endangered Species Act is to act as the domestic implementing legislation for certain treaties to which the United States is a party, because entry into those treaties is not self-executing. So the Congress has to implement legislation in order to effectuate those treaties domestically. So we'll talk more about the international aspects as we get further into this. Another important policy goal of the Endangered Species Act, and something that was really unique, is to set up a framework where all federal agencies, not just the Fish and Wildlife Service, not just the National Marine Fisheries Service, not just the Environmental Protection Agency, all federal agencies have to seek to conserve endangered species and use their unrelated to endangered species authorities to effectuate the purposes of the statute. So when Federal Highways Administration is, you know, looking at a superhighway, or you know, the Office of Surface Mining is looking at issuing a permit for coal mining, those statutes under which they're acting have nothing to do with endangered species conservation, and yet they have to look for opportunities to forward the purposes of the ESA through their various actions. A key term of the Endangered Species Act is this definition of conserve or conservation. Again, this was very forward-looking. What Congress said was, we don't want to just keep species that have been identified as endangered or threatened on loan board. We want to ensure that they not only survive but also recover to the point where the measures under this chapter are no longer less necessary. In other words, get them to the point where their population has grown sufficiently, their habitat has been conserved sufficiently that they can be delisted. So, for example, that's what happened with the bald eagle, that's what happened with the gray whale. Because of either, you know, active conservation measures or more passive measures, those species no longer require listing, and therefore they've been delisted. So, but this is a goal that applies to all species. The intent was not to create a zoo where we would have representative samples of species, but to ensure they would survive in the wild. So I'm just going to go quickly through some of the really key provisions of the statute. And we're going to start with Section 4, which is how species get on the list in the first place. So there's two different categories of listed species under the statute, and the distinction between them has some really critical implications for how species are managed and what activities are and are not permitted with respect to those species. So an endangered species is in danger of extinction. Sorry, that's a typo. It should be in danger of extinction throughout all or a significant portion of its range. And threatened brings in a time element. In the foreseeable future, the species is likely to become endangered, again, throughout all or a significant portion of its range. So the real difference here is, now versus future. A hot topic in Endangered Species Act issues right now is, what does the future mean? Does that mean tomorrow? Does that mean a week from now? Does that mean 50 years from now, 100 years from now? So that is still very much an open question and has generated litigation and is going to continue to do so. Under the threatened bullet point, I bullet for you here Section 4D rules. Under the Endangered Species Act, the statute itself provides a huge list of prohibitions for species that are listed as endangered. It does not do so for species that are listed as threatened. Essentially, it leaves to the discretion of the Secretary, and by Secretary I mean either Interior or NOAA, with the wildlife agencies being Fish and Wildlife Service and National Marine Fisheries Service, respectively. For a threatened species, the Secretary can decide in his or her discretion to promulgate a species-specific rule, essentially, that says these activities are prohibited, these activities are permitted. So there's a lot more wiggle if you have a threatened species designation. It's not, the hammer comes down and all activities are essentially off the table unless otherwise permitted. So for the petition process, of course, the Wildlife Agency can determine to list a species on its own initiative, and certainly the wildlife agencies have done so over the years. But this is also a process by which citizens can participate in the listing process by submitting petitions to the Secretary to list a species. And whichever way it comes up, whether it's a service initiative or a citizen petition, there is a process that involves public notice and comment and sort of essentially more and more detailed levels of review. So at the 90-day stage, if a petition is submitted, the agency just needs to determine that a reasonable person would find that the petitioned action is warranted. So it's basically, up and over this relatively minor standard, and the agency looks at what's in the petition itself, what it has in its files, but it's just basically making, thumbs up or thumbs down, we're going to proceed to a more detailed look. And that all of these have a public notice and comment process. So assuming the agency says, yes, positive 90-day finding, we're going to proceed to a status review, and that's a much more detailed look. The service engages its own scientists. It will solicit comments. It will often work closely with state wildlife agencies, outside experts. Of course, the public can submit this information as well. At the 12-month stage, it says, all right, never mind, the species doesn't warrant action, and that's an off-ramp. Or it does warrant listing, so here's a proposed rule, and preferably a proposed rule to designate critical habitat, another round of comments, and then 12 months later, a final determination, which again can be, all right, thumbs up, we're going to list it, or, never mind, for other reasons, we have decided that listing is not warranted, we have more information, or maybe, states and private parties have taken enough conservation action that we can be assured that the species does not require listing. So Congress established 5 factors. This is, the basis on which the agency has to make its decision about whether listing is warranted. Listing can be warranted based on any single factor or any combination of factors. So even though the service has to go through the analysis of all 5 factors, it doesn't have to find that A plus B equals endangerment. It can be a single factor that warrants listing. an important statutory component is that the agency has to consider what efforts states are making or foreign governments are making already to conserve the species. And I point out here that species entirely outside United States jurisdiction can be listed on under the ESA. So, you know, it's important for the agency to know what a foreign jurisdiction may be doing to conserve the species, and it also, under these factors, has to understand what that foreign jurisdiction's regulatory mechanisms are, so it can determine, you know, whether the species warrants listing. The last bullet point here is really critical. A listing decision has to be made solely on the basis of the best scientific or commercial data available. And there's a couple points I want to emphasize here. One is Congress intended that this decision be made without reference to the economic impacts of listing, the political impacts of listing. You know, all of that is not to be considered in a listing decision. It has to be simply, what does the scientific data say? The other point I want to make is that the word here is not science, it's data. And that's really important because Congress wanted the agency to act even in the face of imperfect data. I mean, science itself is a long, drawn-out process. It's the scientific process that results in peer-reviewed journals and articles. You know, you have to go through a lot of stages to get to that point where something is, you know, accepted by the peer-reviewed science. And Congress wanted the agencies to act even in the face of imperfect data. In other words, don't wait until your science is perfect and then in the rearview mirror you're like, you know, you're right, that species is extinct. Clearly, it was endangered. So the data can be anecdotal. It doesn't have to be peer-reviewed as long as there's no better available to contradict it and the service has made a judgment that it is credible. So, you know, again, as Jamie pointed out, the agency has to show its work. So on the record, it will have to say, well, you know, we had this anecdotal evidence from back before anyone cared about this plant that it occurred in a certain place. So even though no one was going out and doing population studies until much more recently, so, you know, we have this data that gives us an idea of where it used to be, even if it's not there now. Another requirement that the agency has when it's listing a species, when it gets all the way to the end and publishes a rule to put a species on the endangered species list, is it has to designate critical habitat. And this is another, you know, ongoing hot topic. So just a couple of highlights here. It can be it has to be essential to the conservation of the species. And remember, that means like survival and recovery to the point where listing is no longer warranted. But it doesn't have to be the species' entire habitat. The service has to make a judgment about, you know, what habitat requires special management. Is it occupied habitat that we need to preserve now for the species' survival? Is it unoccupied habitat, possibly where the species used to be, but it's undergone a range contraction, but if we want to get it to the point of recovery, we need to designate this unoccupied habitat. There's two off-ramps. The service can decide that critical habitat designation is not prudent. So, for example, if a very rare butterfly is put on the list and we make a map as to where the last 5 butterflies are found, you may get collectors who want to go out and they want one of those last 5 butterflies, you know, dead on a board. So it may be not prudent to designate critical habitat because then you're identifying to collectors exactly where the last species individuals may be found. The service can also say, well, we don't have enough information to designate critical habitat. It's not determinable at this point. All that does is give them more time to do it. So importantly, with respect to foreign countries, endangered species can be put on the list even if they're entirely outside your U.S. jurisdiction, but critical habitat will not be designated for those because it won't have any effect. And finally, as I said before, the species has to be listed without respect to economic or other impacts, but an economic and national security impact analysis does come in at the critical habitat stage, and the service can determine that the benefits or the impacts to some economic interests may outweigh the benefits of designation, and on a discretionary basis choose to not designate certain areas as critical habitat even if they otherwise meet the definition of critical habitat. And we'll talk a little bit more about what critical habitat actually means when we get to Section 7. All endangered and threatened species are supposed to get a recovery plan. This is essentially a roadmap for what needs to happen for the species to reach the point at which recovery can occur. It should include information about what does recovery look like. Is it population numbers? Is it habitat protection? Is it amelioration or elimination of threats? It's not a binding document, it's a guidance document. So it's meant to be a roadmap, but no federal agency or no individual can be sued for violating a recovery plan. It's essentially an educational tool to help guide agencies and other entities and individuals in taking action that might affect listed species. And again, with respect to species outside the United States, we don't do them. This is really meant to be something to shape domestic policy. Although there are some transboundary species that may be between, for example, the U.S. and Canada, the U.S. and Mexico, they may or may not get recovery plans. Every 5 years, the agency is supposed to check in on a listed species and do a status review, which is essentially, how are we doing? Have we gotten better? Have we gotten worse? Is it just the same? Again, there's not necessarily any kind of binding action that's going to come out of this. It will advance the knowledge of where the species is, which may shape future consultations or permits, but it may result in an updated recovery plan. In and of itself, it has no legal impact on agencies or the regulated community. So let's talk about Section 7.
I just say one thing about sleep. I mean, it's all the listing. I don't know if you agree that the listing is not necessarily. It's about the status of the species, how it's doing, its numbers, and is it going to be like extinct or threatened. It's not tied to whose fault it is. I mean, and so often you hear with the listing, a landowner, I didn't do anything. Why are you listing it? I'm like, why are you constraining me? And it's you have disease predation. For instance, in the northern long-eared bats, one of the news, I'm sure you talk about it, but there's a terrible syndrome that's killing bats left and right called white nose syndrome, and one of the issues is you have to list it under the act because its numbers are dwindling, but what the consequences of that are borne by those who didn't lead to the condition. So there's that kind of.
I think that's very important. It's a no-fault statute. I mean, there's no there's no criminal intent requirement in here. We don't just list species because someone did something bad. So I think it is a very important issue. I think the bats is a great example. White nose syndrome, it's an invasive, non-native fungus. But I think the question in the Endangered Species Act says, given that it may not be anyone's fault, what do we do now? Because we still need to do everything possible under the statute to conserve the remaining, minuscule populations of whatever the species is. Section 7 is really the heart of the ESA. 7A1 I won't spend much time on. This I refer to in the policy part. Federal agencies have to do something in order to use their authorities to conserve species. And the courts have found that a particular plaintiff can't come in and say, what is that something? As long as agencies are doing something and have thought about using their authorities to conserve species, they're going to get deference on that. 7A2 is really the heart and soul of the ESA, because this is where every federal agency has an obligation to ensure against jeopardy to the continued existence of any species or result in the destruction or adverse modification of its critical habitat. So this is something that every federal agency, when Federal Highways is building a road project, when BLM is issuing a grazing permit, when FERC is licensing a pipeline, every single agency has a substantive obligation, not just a procedural obligation as with NEPA, but a substantive obligation to ensure against jeopardy to species. So if anyone's ever taken an environmental law class, I guarantee you have seen this citation. Tennessee Valley Authority versus Hill in 1978, 5 years after the statute was promulgated, was about essentially completing the Tellico Dam. I mean, the thing was built. It was built, and we just had one little part to finish off to close in the water and make a lake out of a river in Tennessee. And sort of almost at the 11th hour, they were like, oh wow, what is this little tiny fish, the snail darter, this little tiny fish you can see in the guy's hand. the opposite of a charismatic megafauna. This is an uncharismatic microfauna. It's a 2-inch fish that you would not stop twice to look at if you saw it in an aquarium. It's just a little tiny fish, bait fish. Nevertheless, a law professor and law students at the University of Tennessee brought a case, and they said, look, the Federal Power Administration has to stop this dam project, because once you shut the last gates or whatever it is on the dam, this fish, which needs a river, it needs, shallow river with like water flowing over little rocks, it's going to blink out. There are no more left. It's going to kill all the remaining snail darters. And the Supreme Court agreed. It said, Congress said what it said. It said, and no, you can't have any plainer language that we are going to halt and reverse the trend of species extinction, even if it means that you've already spent, $1 billion or whatever it is on this dam, even if it means you've already made commitments. In this case, actually, I'm sorry, it wasn't the Federal Power Authority, it was Tennessee Valley Authority. Duh. Tennessee Valley Authority was like essentially building this for Boeing. Boeing was like, hey, we'll come to Tennessee and build a factory if you'll give us the power through building this dam. And TVA said, great, we'd love to have you in Tennessee. And so we'll spend a whole bunch of federal money, and oh, by the way, take a whole bunch of private property, because this was like houses around a river that were going to be underwater once the dam was constructed. So we're going to displace all these people. We're going to, build you your power source, and who cares about the snail darter? And the Supreme Court said, no, Tennessee Valley Authority, whichever agency you are, conservation of endangered species has to be the first priority, even above your congressionally stated mission of, build dams to provide power to industry, or, build highways, or whatever it is. Essentially, again, reinforcing that, Section 7, unlike NEPA, really is a very powerful hammer. Supreme Court said there's no exceptions. You cannot jeopardize species without going through the consultation process. So this is the substantive obligation of every federal agency. They cannot jeopardize species, which is an appreciable reduction in both survival and recovery. They cannot destroy or adversely modify designated critical habitat. So in order to get to the no jeopardy outcome, action agencies who are undertaking, a discretionary federal agency action, which they authorize, they fund, they carry out, a permit, their own action, whatever it is they're going to do, they have to engage in the process of Section 7 consultation. What they have to do is they have to go to the wildlife agency and essentially engage in, something that looks a bit like NEPA's process in terms of like there's different types of consultation that can be engaged in for any of their actions. One thing I wanted to flag here is, as Jamie mentioned, discretionary really is key. If the statute says if A plus B happens, then C is the result, and there's no discretion, then Section 7 consultation obligation is not triggered. And the Supreme Court cite here is to a case in which EPA was determining under the Clean Water Act whether a state had met the preconditions to have the Clean Water Act permitting program delegated to it. And the statute set out a list of factors saying, if your Clean Water Act permitting program has these indicia, then EPA shall delegate it to you to administer yourself at the state level. And this particular case, the Supreme Court said, there's no discretion. Once EPA has checked all the boxes, it's a pass-through. The state gets the delegated authority. There's no room for consultation because EPA can't protect or otherwise benefit listed species through this particular, statutory pass-through of authority. So, in looking at what requires consultation, you have to have an action, and there has to be discretion by the federal agency in order to condition that action to benefit species. Another place this resonates with NEPA, as Jamie was talking about with direct versus indirect effects. It's the same thing with consultation. You not only have to look at your particular wetlands that you're filling, but what are the downstream impacts on connected wetlands? You can't just look at, what about your particular trees that you're cutting down? What impact does that have in like the larger forest ecosystem. So, that the action area is more broadly defined than simply, where is the exact impact going to occur. Downstream impacts are very important. So, again, because the ESA does have this large international component, it's important to point out that federal agencies don't have to consult on actions that are, going on overseas. So from the Section 7 side, this is very much a domestic orientation. And the case citation here was looking at, the U.S. is funding projects overseas that may affect those projects overseas. What is the consultation obligation there? And even though everyone knows this case because of what it said about standing, ultimately, like, the facts of the case hinged on what kind of funding can we give overseas, and what, if any, kind of consultation obligation does that trigger. And there's actually been some more recent litigation as well concerning, like, the Import-Export Bank, or whatever you call it, again, where courts have essentially said, no, it's really got to be what can U.S. agencies control within their jurisdiction, whether that's, the actual land mass of the United States or the high seas with respect to, for example, U.S. fisheries that operate on the high seas, but they're regulated by the National Marine Fisheries Service. So getting to the actual nuts and bolts of the consultation process, like NEPA, the first thing to do is the action agency has to determine, essentially binary, no effect on listed species or may affect listed species, or I'm just going to include critical habitat and all that. And may affect includes beneficial effects, but that is part of the question. There can be beneficial effects, there can be adverse effects. A no effect determination is an automatic off-ramp. You do not have to go into consultation, and you don't even have to talk to the wildlife agency. As long as you, the action agency, have made your no effect determination, you should support it in a record in case anyone ever comes after you for it, but you don't have to start that consultation process with the agency. May affect leads to an informal consultation requirement, and this is like the EIS process. If you're fairly sure that your project is going to have real impacts on listed species, you should just go to formal consultation. But there may be a question, maybe you've only got beneficial effects involved, or the action agency is not an expert on these particular listed species, and it says, well, we think these may have adverse effects but are not likely to adversely affect. So they go to the service in what's called informal consultation, which is a catch-all phrase meaning any communications whatsoever. It can be phone calls, it can be emails, it can be, water cooler chats, whatever it is. It's a very loose process, an umbrella that, covers a wide range of, potential communication methods. And if the wildlife agency says, okay, thumbs up, we agree in writing that your project is not likely to adversely affect species, they give them a concurrence, the project may proceed. If they don't concur, or if it's likely to adversely affect that's sort of clear on its face to the action agency, then they just head to straight formal consultation. So the two important documents to be aware of in a formal consultation, an action agency will often prepare what can be termed a biological assessment or a biological evaluation, but they need to do their own effects determination. They have to consider the baseline, like what's the status of the species, what's come before that has put the species in the place it is, what are the effects of the action going to be, again, very NEPA-like, direct, indirect, interrelated, what are the cumulative effects going to be, and then they take that to the wildlife agency to get a biological opinion. Both agencies have to use, again, the best available data. It doesn't have to be perfect data, but it does have to be the best available. So once the service starts doing its part, they will either determine no jeopardy from the project or jeopardy from the project. And if it's no jeopardy, then they'll say, here is your incidental take statement to the federal agency, which essentially gets the agency and the project proponent, to the extent that there's a permit, out from under Section 9 liability, which we will talk to in a minute. So the incidental take statement has to say how much take is permitted, how much can you harass, harm, kill, or otherwise impair this species and still be under this no jeopardy threshold? And what should you do to minimize the impacts of take? Can you, make sure all of your equipment is in this one non-sensitive place? Can you, ensure that you've got like silt fences up or something so that you don't have sedimentation going into a water body? What are those going to be to minimize take? And then there's terms and conditions, and these are, mandatory, and they include reporting. So we have to be able to monitor what's going on, and we have to be able to actually enforce these reasonable prudent measures. And as long as there's still discretionary involvement and control by the federal agency, then there's a requirement to reinitiate consultation if there's new information, there's a new species listed, your take trigger is exceeded, you've got to go back and reinitiate consultation. I'm going to only talk very briefly about jeopardy, mainly because I'll just give away the punchline here. It never happens, or at least hardly ever happens these days. But the important thing to know about a biological opinion is it is just that. I mean, it's an advisory opinion. It may be in effect, something that the action agency ignores at its own peril, but technically it's an opinion, and the action agency can do what it will with that opinion, and it can say, fine, we're totally going to live by all of this, or, under the rare circumstance of a jeopardy call, when the service has prescribed a reasonable and prudent alternative to jeopardy, which is sort of like NEPA. It has to meet the same purpose of the action, but here's a way that you can do it that's not going to jeopardize the species. It can modify the project, it can abandon the project, or it can just say, we disagree, and, at its own peril, it can decide not to implement an RPA. Or it can go to what is known as the God Squad, which is very dramatic, but we're only going to spend like 3 seconds onto it because it's essentially turned out to be a not very exciting story. Yes, it totally is. So the God Squad was essentially Congress's reaction to the TVA v. Hill decision, and they said, we're going to set up a committee, and the committee can decide, never mind, shut the gates on the Tellico Dam. The Tellico Dam is more important than the Snowdriver, and you can extinguish the species and, go in peace. It's only ever been convened 3 times, so, despite this big brouhaha, it's really been pretty meaningless. What this slide shows is, much as in the NEPA context where you have mostly categorical exclusions and then a lot of EAs and then very few EISs, the same thing holds true with consultations. The blue bars are informal consultations and the yellow are formal consultations. So, most of the consultation process ends in the, not likely to adversely affect. And that may be because agencies are working either on their own or with applicants to avoid these impacts up front, so they don't have, so it's like kind of like a mitigated Fonzie. They're looking to get out from under the, the time, the expense, the hassle of a formal consultation. Or it may be that, the projects may just not really be having significant impacts. But I will refer you to this website that I have linked on the bottom of the screen. And it takes you essentially to a giant database of all consultations that the Fish and Wildlife Service has done since 2008. And you can look at them by, what are the most consulted on species? That would be the Indiana bat. What's the geographic regions of the United States where you get more consultations versus less consultations? There's a lot of fun ways you can play with the data, and this is all from a Fish and Wildlife Service database that colleagues of mine at Defenders of Wildlife have put together in a very, open access, publicly accessible format. One thing that became clear from, my colleagues' analysis of all the consultations between, 2008 and now, is that the ESA does not stop projects. This is one of those sort of persistent myths, like we can't get anything done in this country because the Endangered Species Act stops us from doing projects. And it's simply not true. The vast majority, and when I say majority, the minority is so infinitesimal as to be almost non-detectable of projects either end in informal consultation or they get a no jeopardy finding. So there may be, reasonable prudent measures, there may be terms and conditions, but the projects proceed. Another way of looking at this data, this is data showing over time how many consultations and formal biological opinions have actually ended in a jeopardy call. So if you look at 2008 to 2015, there were 2 jeopardy findings. Actually, one of those went back on remand after a court decision and ended up in a no jeopardy situation. But that's equivalent to 0.03% of consultations. So the idea that you can't get anything done because of the ESA, it's a non-starter. Another thing the data shows is that for whatever reasons, the services are much less likely to call jeopardy now than they were in past years. And the paper that was published by my colleagues in the Proceedings of the National Academy of Sciences, gets into some of the potential reasons for that. Of course, we can't really answer that. There's a number of potential reasons. Again, maybe projects are just being better designed. Maybe agencies have figured out how to mitigate impacts in consultation, or maybe the federal wildlife agencies are getting rolled because it's so politically difficult to make jeopardy calls. And of course, you can't come up with a single answer because there's such a wide range of numbers, but all of those may be true. So let's talk about Section 9, which is the take prohibition of the statute. And this is, the teeth of the act. So this is broader than Section 7. This applies to any person. Any person is broadly defined to include not only individuals, but also, states, also federal agencies. So it's really extremely, extremely broad. And take itself is very extensively defined. It's really meant to encompass like any possible bad thing you can do to an endangered species, and including by regulation, harming it by modifying its habitat in such a way as to actually kill or injure it, including by interfering with feeding, breeding, or reproduction. So you just have to think of Section 9 as broad as you can possibly think. There's both civil and criminal penalties available for violations of Section 9. Of course, this can only be brought by the U.S. government. But it is a really extremely broadly drafted statutory provision. If a private party, a regulated entity, wants to get coverage under an incidental take permit, but it doesn't have a federal nexus such that it needs a 404 permit or it needs some other federal permit, that it can acquire Section 9 take liability via the Section 7 consultation process, it can come to the service for a Section 10 permit. So this is something that, again, if the take is incidental, i.e. not intentional, as long as it has gone through the process to get this permit involving getting a habitat conservation plan together, telling the service what it's going to do, how it's going to minimize the impacts, what kind of offsets it might have. Maybe it'll have, relatively minor impacts over here, but it's going to put money into a mitigation bank so that higher quality habitat could be protected over there. How we're going to pay for this, why we're doing it the way we're doing it. It's going to get an incidental take permit, which, by the way, is a federal action requiring Section 7 consultation. So in issuing this permit, the Wildlife Agency has to do a self-consultation where it is the action agency for issuing the permit and the Wildlife Agency for giving a biological opinion on the permit. So I know we're racing through this, but Section 11, very important, very near and dear to my heart as an ESA litigator, is judicial review. This is another place where the terms are very, very broadly defined. So the ESA has a citizen suit provision which enables any person to commence a civil suit to enjoin any person, defined to include U.S., other governmental entities, to the extent permitted by the 11th Amendment, if you're talking about a state, who's alleged to be in violation. An important emphasis here is that this is about future prospective relief, i.e. injunctive relief. So this cannot be used to go after someone who took endangered species in the past. It has to be about, you're about to finish your project, and when you do that, or you're about to commence your project, and when you do that, you're going to harm endangered species. You haven't gone through the process to get your, incidental take statement or permit. Therefore, we're going to seek a court injunction to stop you from proceeding without that coverage. The citizens can also sue the Secretary of Interior or Commerce when there's been no performance of a non-discretionary duty. So this is really like mandamus. and the place where this really comes into play is with all those Section 4 deadlines. So if the agency misses the deadline for the 90-day finding, the 12-month finding, or the 24-month finding, this is where citizens can come to the court, and the court says, yes, the statute was clear. You had a clear non-discretionary duty to meet this deadline. You blew it. Here's the order telling you when you have to have it done by. No matter what you say about, gosh, it's really hard. We have a lot of work to do. We have no money to do it. Essentially, it's a clear duty. Under the citizen suit, there has to be 60-day notice to the federal government, the potential alleged violator and the agency, which is essentially like a safe harbor time, a cooling off period. And the notice letter says, here's what you've done that's wrong. Here's how you violated the statute. Please get in touch if you'd like to resolve this short of litigation. And this is essentially a jurisdictional bar to litigation. If you don't do your citizen suit notice letter, no matter how urgent you think it is, the courts will boot you. You will get kicked out of court, and you'll have to go back and start over. Even if it's, the sky is falling, the snail darter is about to go extinct. One important issue, though, that came about as a result of this litigation in Bennett v. Speer is that the Supreme Court distinguished between, violations that can be remedied or under the citizen suit provision and the service's own violations through maladministration of the Endangered Species Act, which cannot be pursued under the citizen suit. So now we have a situation where there may be citizen suit claims, like, for example, a case may be brought against a federal agency, an action agency, for failure to consult, or a consultation that the plaintiff disagrees with the result of, and the plaintiff may bring an APA-based action against the service for a bad buy-up. So, in the service, in its role as administrator of the ESA, cannot be sued under the citizen suit provision. But in both sets of cases, the APA supplies the scope and standard of review. So generally, administrative record review and arbitrary and capricious, unsupported by substantial evidence, et cetera. I just want to briefly mention, again, as I referred to in the beginning, this statute has a big international component. It can provide carrots to other countries for conservation of species. It also implements really important international conventions such as CITES, the Convention on International Trade in Endangered Species, and it essentially authorizes the Secretary of the Interior to implement that statute, which is essentially a trade regulation, I shouldn't say statute, treaty. It's a trade regulation treaty that may require import or export permits. And one of the reasons it's really important is because both legal and illegal wildlife trade are huge. Like illegal wildlife trade, of course, it's hard to get exact figures on because it's illegal, but it's probably up there with, drugs in terms of the value, in trade of illegal wildlife trade. So it's really important that the ESA is the implementing statute for CITES because the U.S. is a huge player as a market in both legal and illegal wildlife trade. So Section 9 has some really important prohibitions on commerce in listed species. So even if it's, legal to take a species in the country of its origin, if it's listed in the U.S., it may not be legal to either transit through the U.S. or bring it to the U.S. and sell it because of Section 9's prohibitions. So has the endangered species worked? This is another criticism that we often hear about the ESA. It's like all you ever do is list. You never get any delistings. It's so expensive. It's just this huge regulatory burden. I certainly don't think the ESA can do everything to protect endangered species in this country. There's a lot of other things that have to happen. But, in general, even if it hasn't been able to conserve species to the point where they can all be delisted, it certainly has kept many species from becoming extinct. So, there's certainly more that can be done. I just want to very briefly go through some ESA hot topics. The ESA has the dubious distinction of perhaps being the most hated statute in, this iteration of Congress. So, we're at 111 bills and counting in this congressional session.
What's your second to Obama?
I'm not sure. We'd have to do that count. But, okay, let's say most hated environmental statute. let's say, most hated environmental statute. And some of these may be, you know, like, let's just repeal the ESA. Many of them are, you know, agency, you do not have the discretionary authority to move forward with a lesser prairie chicken listing, or, you know, you have to go delist gray wolf. So they really run the gamut. But if you're interested, both Defenders and Center for Biological Diversity have giant lists of bills that have been introduced, none of which have succeeded, thankfully. But it's a huge time for conservation organizations in terms of legislative defense. Certainly, there's no view towards like, oh, I don't know, let's open up the statute to reauthorize it and improve it. And you know, the other sad fact is that federal funding is really insufficient. So one of the criticisms of the Endangered Species Act being that it doesn't work, one of the answers is, well, gosh, it'd be really nice if Congress actually appropriated sufficient funds and didn't earmark them such that 80% of all federal spending by, essentially by appropriations measures or whatever goes to fish. 5% of listed species, and then we're talking like salmon, sturgeon, other species like that, and they just get the lion's share of money. And many species like squeak by on like, okay, we can spend $1,500 on your conservation this year. So there's also a lot on the administrative side. As we said, regulations are everything, and the Obama administration has proposed or finalized a bunch of regulations that affect how the Endangered Species Act is administered. Here I've really only looked at ones that are like literally within the last year, but if you go to the Fish and Wildlife Service's website, if you like look it up under like ESA reform or improvement or whatever, they actually have a very nice website with a flyout menu that sort of marches through the stages of the listing, consultation process, et cetera, to say, here's how we have revised, tweaked, amended these regulations, some of which have been in response to judicial decisions, others of which are really aimed at, in their view, streamlining or improving the listing and consultation processes. So I'm not going to go through any of these individually, but I have put the citations on here for your further reading enjoyment after the show. Also, litigation. Again, we got three branches of government here, and the ESA is always a hot topic amongst all three branches. But some areas I wanted to call out, especially because these paired cases are very interesting underneath their particular topics because they came to very different conclusions on very similar facts. So one of the ways the services can off-ramp a proposed listing is if they say, you know what, there's enough conservation efforts going on at the state or the individual level that the species will be sufficiently protected into the future such that listing is not warranted. And two recent cases, the dune sagebrush lizard litigation we brought concerned this lizard in habitat in Texas and New Mexico. The service proposed it as endangered, and then essentially the Bureau of Land Management, the state of Mexico, and the state of Texas all had these conservation programs they set up. And for Mexico and New Mexico and Texas, essentially like this is all private land. There's really no Section 7 hook. It's, a lot of these places there's no federal land to protect the species on. So it's really essentially of the grace of individual landowners that say, we want to do good things for these species, so we're going to enroll our lands in these conservation programs that the states are going to administer. And the service said, okay, that's all enough to make a finding that the species does not warrant listing as endangered because under your policy for evaluation of conservation efforts, you've made an appropriate judgment supported by the record within your realm of expertise that gets deference that, these voluntary, unenforceable, in Texas's case, secret efforts are enough. So the D.C. Circuit upheld that decision. I will say, as a factual note, Texas has now fired the organization that its former comptroller hired because it found that actually no conservation was happening. But that's a factual issue sort of outside the scope of the administrative record at the time that the final decision was made. On the flip side, in this Permian Basin case, This was concerning the lesser prairie chicken, which the service finalized a listing of as threatened, and there had been sort of like a range-wide, plan set up under which, again, landowners could enroll their lands and do good things for the lesser prairie chicken. And the service said, this is great and all, but we have to make this listing decision because no one's actually enrolled yet. And so, this was like 5 different cases brought in 5 different places. And the one that got to a final decision first is this one, in which the district court overturned the listing of the lesser prairie chicken because he said, you know what, you should have speculated more about how many landowners were going to enroll and what the effectiveness of that was going to be, and therefore, you didn't do enough speculation about future conservation benefits, and therefore their listing is arbitrary. And when you put the 2 decisions side by side, one of the really striking facts is how much deference the service gets under the D.C. Circuit's case and how little deference it gets under the Western District of Texas's decision. So, it goes to show you that, deference is in the eye of the beholder.
They're going to list it again.
What?
They're going to list it again.
Well, there's been no final decision as far as I know. So, so even though obviously we have these standards, courts can apply them in very different ways to reach very different outcomes on, if not identical, at least factually comparable circumstances. Jamie alluded to the northern long-eared bat. This was a species that was proposed endangered, and there was a final listing as threatened. There is now 2 consolidated cases in the D.C. District Court, one of which brought by my organization and the other by Center for Biological Diversity, and that case is going to focus around, as I mentioned before, the definitions of endangered and threatened. When is a species endangered? What's the time frame for foreseeability on when it'll be threatened? And can the service say it's threatened in all of its range, therefore we're not going to look at whether it may be endangered in a significant portion of its range? So, there's additional facts in there, and there's going to be 4D rule litigation, but this is all by way of saying, however many years after the Endangered Species Act, there's still a lot of discussion about some of these really, fundamental statutory terms. What does endangered or threatened mean? And I also just wanted to, give you another pair of cases with respect to climate change, which is, definitely a hot topic just about across every aspect of environmental law, but certainly with respect to endangered species listings. The polar bear was listed as threatened in 2008 because even if we still have plenty of polar bears running around, the service found that, over time, climate change was going to shrink its habitat enough to the extent that it was foreseeable in the future that it would become likely to be threatened with extinction. 2 recent cases that are, came to very different conclusions on this question of forecasting based on climate change. The first one involves the wolverine, which is dependent on snow for denning, for making its, for breeding and reproducing. So it needs snowpack, and as the snow melts, it has nowhere to reproduce. As the judge cited the plaintiffs, is essentially like a remnant of the Ice Age. And in that case, again, the service proposed to list it, and then one of the reasons the court overturned its decision to withdraw that proposed listing was it found that the service had, discredited or ignored the results of the best available scientific data and studies, and instead, relied on some 11th hour, charitably speaking, attempts to pad the record to say, no, we can't rely on that science after all. And so that's one, very important recent case to look at in terms of, not only the climate change issue, but how do courts treat the service's treatment of the data, especially if there's conflicting data, later posted data, so things like that. The other case that I've cited for you here on the Arctic ringed seal, the National Marine Fisheries Service had determined to list, 5 subspecies of this seal. Again, like the polar bear, depends on snow and ice. And as that melts away in Alaska, NIMS determined that, over about the next 80 years, the species is threatened now because it's foreseeable in the future that it will be become threatened with extinction. And there, again, court did not defer to National Marine Fisheries Service on any of this. It basically said 80 years is way too far in the future for us to speculate. It's too remote. It's too speculative. It didn't actually find that anyone cited any contrary data. The court basically said, this is too remote and speculative, and you haven't done enough to show me your work. So again, two different courts, two different views of how much deference an agency should get. So my very last slide. Some of you may have seen this in the news. This is the Bramblekeys melones, if I'm pronouncing that right. It has the sad distinction of being the first mammal that has likely become extinct because of climate change. It was the only mammal indigenous to this little tiny island on Australia's Great Barrier Reef. Scientists have no longer been able to find it. The island is shrinking because of sea level rise. So, certainly other species have already gone extinct, but this appears to be the first mammal to become extinct because of climate change. And as a paper published in Science, cited to here, says 1/6 of the planet's species may follow suit. So I will, on that extremely depressing note, end and say that, the problems are not yet solved, either under the Endangered Species Act or other mechanisms to try to address this extinction crisis that we're in.
I just want to raise two things that just complementing your point. I think it just bears re-mentioning that Endangered Species Act permits that you get from the Fish and Wildlife Service, and we're talking incidental take permits, are very different than a Army Corps 404 permit, a Clean Air Act permit, any of the other BLM permit, any other permits you typically see, because it's not an affirmative permit you need to go get. People get it defensively. People get it because they don't want the exposure to take, and people even get it for things that aren't listed yet because they might become listed in these candidate species that are under study. So it's about protecting your project. If you're going to have a 30-year project, you don't have to reinitiate 15 years in. The only other thing I want to say is that listings, pay attention to the listings, because we're going to have a lot more of them due to Jane's and other organizations' good work and achieving a couple big mega settlements where there are going to be hundreds of species between now and 2018. 19.
Those aren't our settlements technically, but you're right.
Yeah,
you're
sorry.
Right.
Yeah, I forgot you. But I'm sorry to paint the same brush. But the 2008, about 2018, 2019, there are hundreds of species that are in candidate land that need to have a final decision made under a court order. And
there's also just lots of others in the pipeline.
And others in the pipeline too, but again, straining the resources, and you could look in the Federal Register every couple of weeks, you'll see something on them. So again, pay attention, because some of these have very large ranges that would impact a lot, and some of them are a little pocket in New Mexico that that don't. So.
Well, I know we're taking up almost all the time, but we would really be happy to stay and answer whatever questions people have.
Fantastic. I wanted to thank Jimmy and Jane for that very comprehensive overview. I will address one question from our online audience, and then if people are available to stick around a little bit longer, we're happy to field a couple of questions from those in the room. So the question we have is, to what degree does a federal agency need to consider alternatives when conducting NEPA analysis? Are there consequences if an agency fails to consider reasonable alternatives?
Yeah, well, again, the test is a reasonable range of alternatives. Your exposure, if you fail to consider a reasonable range, and again, it's in the eyes of the beholder. If a judge feels that you did not exercise reasonable range, consider a reasonable range of alternatives, they will kick back the record of decision for basically a redo of the NEPA analysis. There may not be a new decision. There may be a supplementation of the NEPA analysis, and where it go back up and be challenged again. But your exposure is your project would be delayed through a remand. It could be basically killed if there's a financing or timing aspect to it. And then that's your exposure. So it's hard to answer the question globally, but it's the question. Having been in the room for a lot of projects, it's the first after purpose and need, what are the range of things we are not going to look at.
And I'll just add to that as well that obviously there's, if there's a private project involved, there's the proponent's goals that will meet the proponent's objectives and needs, but then there's also statutory constraints in terms of, what the agency can do in terms of permitting or whatever. So, I think that there's an interplay. A reasonable alternative has to not only address like the scope and need, and the federal agency is doing this, and if they're doing it for someone else, that has to be addressed. But the agency always has the sideboards of its own statutory and regulatory authorities and constraints on what it can do in terms of coming up with an alternative.
Thank you both. At this time, we'll be wrapping up the webinar portion of this presentation. Thank you all online for joining us today. And let's give a quick round of applause for our speakers. So for those of you in the room, are there any questions?
So I was just wondering, in the face of climate change, a lot of species ranges are shifting northward and upward in latitude, or like elevation, sorry.
Mm-hmm.
How does that like play into the whole permitting thing? Because like you're not allowed to make retroactive changes, right, to a permitting decision. So, or are you? I'm not a lawyer, sorry. But
I think it's definitely a hot topic question. I mean, I think it's one of those, people are in agencies in the private sector and, the scientific community are beginning to really grapple. Like if you have...
it's in the critical habitat.
Right. So, I think, one answer to your question with respect to the permit is, again, going back to, is there still discretionary involvement and control of the federal agency over a particular permit under the ESA Section 7? Maybe new information comes in that says, climate change is affecting the species in a way that we didn't consider in our consultation, and now we have to reinitiate consultation to address this information. But, if the permit is like a one and done, like you've gone and you've filled your wetlands and there's sort of nothing else to do and the agency's permitting involvement has come to an end, then, there's really nothing to do at that stage. But I think it sort of opens up the question of, how do you consider impacts and what's your time frame? You're going to fill the wetlands today, but does that mean that you've taken a species that now it's like habitat is shifting northwards? Does the agency have to say what might happen 30 years down the road is, a direct or indirect effect of the action? So I think these are really tough questions. I think it's a hard, because we're all, with respect to these species, speculating on, what's going to happen, and it's really, I think, a very challenging question for, ultimately the permitting and consulting agencies to have to grapple with.
Yeah, I mean, based on the rulemakings and policies that are out, I think if you ask this Fish and Wildlife Service, they would just say yes.
Right.
They would say we must consider not only habitat that's established, but where the species has never been before, because that may be appropriate habitat in the future with climate change.
Mm-hmm.
So northern latitudes, how the species may react to spawning grounds traditionally, if they will be abandoned in front of others. So there's a good amount of speculation, and that's an issue. It's just, if you're making decisions, how confident do we have to be before we say yes, you need additional permit coverage to you face enforcement risk by building in these areas. And again, critical habitats for federal action, they're the most sensitive, so they will share what fish is doing under this administration.
If one of the objectives of the ESA is to avoid species becoming extinct, which I would define as the absence of the species over some period of time or otherwise zero, it seems to me that there's a great deal of need for knowing how many are out there of this particular species at a given moment in time. And so my question is, role of population surveys under ESA?
Well, first of all, certainly the bottom line goal of the ESA is to prevent extinction, but it is also to, ensure that species not only survive but also recover. But the question of population estimates is a very tricky one. I mean, the ESA doesn't actually require a census. So, one of the things that the service can do and has to do often in terms of, its obligation to rely on the best available data is try to make determinations about, relative abundance now versus relative abundance at some comparative point in the past that we can make, an objective but perhaps qualitative finding that it is now endangered or threatened. And I think there's a lot of challenges on population studies. I mean, number one, back in the day when they weren't endangered, no one was necessarily going out and doing population studies. So can be a dearth of historical data, at a time when they weren't endangered or threatened to compare it to. There may not be a time series to say, we have 100,000 now. Well, is that compared to 150,000 40 years ago, or is it compared to 100 million 40 years ago? And, oftentimes we just don't have that kind of information, so the service has to use what data it has. So just to give you one example, like with respect to the northern long-eared bat, which was relatively recently listed as threatened, there isn't sort of range-wide data on how many bats there were before white-nose made its appearance in 2006, and the population trajectory looks like an airplane, diving into the ground. So one of the sources of information that the service relied on in making its finding is, looking at hibernacula surveys. So these are hibernating bats, and they hibernate in hibernacula, and it was looking at, like, okay, where they are in the winter, where we can go count them because they're sleeping in caves. We're now seeing like a 99% decrease in these hibernacula. So, it just simply didn't have the data to say there was 100 million bats before and now there's 1 million. But it was using the data it had to say, essentially, this is a proxy for, where the population was then versus where it is now. And, in other situations, it may have to make similar, scientifically grounded but not conclusive determinations based on habitat. What's the extent of habitat the species had then versus what it is now. So, in an ideal world, we would know, there was 100 million bats then and there's 100,000 now. But, we simply can't wait for that, that data to come either by counting them now. They may be impossible to count. They may not have that time series. So, the services have to do the best they can with what they have, and it has to have a reasonable basis, and it has to be, credible data. But, there's just simply not the ability or even necessarily the time or the funding to get, sort of like absolute measure. And then, of course, the question is, what do you compare that absolute number now if you don't have what it used to be? So it's all, one of the regulations that I cite there in terms of incidental take. The ideal when you are specifying incidental take in Section 7 incidental take statement is to have like a numeric number. You can take 10 fish, and if you take 11, then you have to reinitiate consultation. But again, it can be really hard to quantify take, especially if you have a cryptic species or, no one ever sees the body. I mean, you just, the individuals may die, but how do you know that they're dead? So one of the purposes of this particular regulation that I cited in my presentation is to say, the service can establish a surrogate for incidental take. So instead of saying we have this many dead bodies, we can say we have had, this amount of habitat destruction, or another species that may be in the same area and is, kind of a one-to-one surrogate for take, but is somehow easier to count. We can use that as a surrogate or a proxy, as long as it's, reasonable and it's identified why we can't just say 10 dead fish. But I think it's a problem that the services have to grapple with, both on the listing and as well as on the steps after that with like saying, you know, how much take is okay and how do we know that, and how do we measure that?
Yeah, I mean, I think it's more important on the project side. I mean, you know, species surveys are standard. I mean, for projects when you're developing these habitat conservation plans, it's not always project by project. Some of them are statewide, multi-state, and that measuring and counting is a big part of that. Is the species present in my area first of all, and second, what are its levels? And so I think that's a big deal. And also certain species, we didn't get to talk very much today about eagles and migratory birds. They are protected under different regimes or different acts, Migratory Bird Treaty Act and the Bald and Golden Eagle Protection Act. They really have a no net loss type of mandate where you are I mean, it is by the eagle. I mean, and there's new rules proposed now about how we're going to measure, what range. But yeah, I mean, that it really is counting. I mean, how many, how many carcasses did I have? How many carcasses exactly? And then that really is more precise. With I think there's an understanding with a fish. You can
I mean, some things are more countable than others. I mean, you can find a dead eagle under your wind turbine. If you have a little tiny bat. And it went into the path of a wind turbine, and the impact of the force of the wind generated resulted in barotrauma. In other words, it was like got internal damage and it flooded off and it died, and it's this big to start with. How are you going to see it? Or your 2-inch fish. No one's ever going to see the bodies. So the agencies have to figure out how do we account for the fact that some dead bodies are easy to count and others not so much.